Biggest issue in your case is here at last. You and your spouse own marital property together. Specifically, you and your spouse own real property together: a house, a condo, a McMansion, maybe a tiny little strip of land, whatever the case may be. But here specifically, let's say that you own a house. You were married in 2013. You were divorcing in 2024, hoping to potentially end your case by the end of the year. If this is an uncontested case, if it's contested, well, perhaps sometime in 2025, or if you were super unlucky, 2026. God forbid any further beyond that. So we have a circumstance now where you have to equitably divide your marital home. How is that done? And what choices do you have? As far as you know, what would the court do? What might your attorneys recommend? What can you two do together? And who has to be involved? How much do they have to be involved? And what kind of preparation do you need? First and foremost, the most obvious option in a divorce case when you have minor children is one parent typically wants to stay in the house. Unless your debts are insurmountable and you have no choice and you have to divide your property, typically the parent that wants majority time sharing or to keep the kids in their current school district, that parent will generally want to stay in the house. Can that parent afford to refinance? What if they make $40,000? It's worth $600,000, and to refinance is at 6.7 something percent, maybe as high as 8 or 9%, depending on your credit worthiness. Well, then that may be impossible. That option might be, forgive the expression, foreclosed to you. Perhaps it is actually the other parent that can refinance. But then you want to be the spouse and the parent that lives in the house, not the other side. Can you broker some sort of an agreement where maybe you pay rent and you continue living in the house? Can you do this in an amicable fashion? Can you think creatively for the best interest of your children, or is this an all or nothing proposition? Because if this is an all, oh, come on, no way. If this is an all or nothing proposition, if this is an all or nothing proposition, then you are in the position where you're going to have the house sold. And an appraisal might help with determining the true value of the house. If an appraisal cannot be done and the house needs to be sold, are you going to do it on your own terms? Or is this one of those cases where you have to wait for an order from the court for the judge to command your home to be sold on an interim basis, or perhaps all the way at trial someday, so that you can continue living in your house as long as is feasible? Well, if you sell your house, that is not the end of the inquiry. Because even if you agree to sell your house, or if the court forces you to, you still have the possibility of where's that money going? The proceeds from the home after any associated costs. Perhaps after taxes are factored in, though divorce attorneys typically do not give tax advice, you will need to seek counsel from a CPA in order to determine any liabilities, perhaps an investment advisor for reinvesting in a primary residence. All that aside, if a court orders you to sell your home or you volunteer and have some sort of a joint stipulation or a settlement agreement to sell your home, then do the proceeds go to A, your mutual credit card debts? How much debt is yours? How much is hers? Does it go to pay off a certain car? Does it go to satisfy a HELOC, home equity line of credit? Does it go to satisfy some other marital debt or even non-marital debt you've both agreed to before those proceeds are equitably divided? That is the $1,000,000 question. If you two can agree on these things in the context of an amicable divorce or a settlement somewhere in the halfway part of your case, then perhaps you can avoid a lot of unnecessary things. Perhaps you can avoid an appraisal. Perhaps you can avoid additional fees from a legal standpoint for litigating an issue that is likely to already be determined in a certain manner. If you cannot afford to refinance a house, cannot afford the mortgage for the house, and cannot afford to stay in the house, why should a court award you to stay in the house? Why should the court punish the other party, force them to remain potentially on the mortgage, and force them to pay for a house that they are not living in, want to have sold, and when it makes more sense for the parties as marital debts, and for their financial futures for the home to be sold. So those are the general three configurations. One is perhaps both parties stay owners of the house, one rents the house from the other, or some configuration thereof, however creative you can be. Two, one party refinances and remains in the house and buys the other party out. And that other party wants to be paid off right now if you can agree in the equitable share. They don't want to be paid over a period of 6 years because then they might have to enforce that action in court someday. Or three, either you do it on your own or the court, as a default position, is very likely to order you to sell your home and command a realtor to assist in this process or appoint a special master, whatever needs to be done to force the cooperation of the parties so that nobody is financially devastated from the continued ownership of a home that, in the case of a divorce, is now unaffordable. This has been another episode of the Best Florida Family Law Podcast. Nothing stated here today is legal advice. This is strictly informational to give you an idea of some of the issues that happen in the context of a family law case, and particularly a divorce. We hope that this has helped educate you. We've not established an attorney-client relationship. If you wish to do so, call our office. We would love to speak with you, and we will be happy to bounce ideas around with you so that way you can have the best possible idea of where your case is headed. Thank you very much.